The breaking news today is that the Justice Secretary, David Gauke, has announced he is not going to pursue a legal challenge to the decision to release the rapist John Worboys on licence. The parole board announced in December that the former black cab driver would be released at the end of this month, as its panel was confident he would not reoffend. Let's listen to what Mr Gauke said in the Commons this morning.
Having taken considered and expert legal advice, I have decided that it would not be appropriate for me as Secretary of State to proceed with such a case. Honourable members will appreciate that I cannot go further and expose details of the legal advice I have been given. I know this will disappoint the victims in this case and members of this House. Given the crimes for which he has been convicted, on a personal level, candidly, I share those concerns.
That was David Gauke, the Justice Secretary. Our Home Affairs correspondent Daniel Sanford joins me now. As he said, victims will be very disappointed, as will many others. Was he right to raise the issue of a judicial review in the first place, Daniel?
Well, certainly his decision raised some eyebrows, because the idea of the Justice Secretary judicially reviewing his own parole board would be something that was highly unusual. We, of course, don't know the nature of the legal advice that David Gauke was given, but he's now made a decision not to pursue a judicial review himself. But that does not prevent any of John Worboys' victims pursuing a judicial review, and certainly we know that two of them will certainly do that. They've already gone through the process of exchanging letters with the parole board, warning of their intention to launch a judicial review, and papers will be lodged on Monday for that judicial review, and there's been assurances given that John Worboys won't be released until that judicial review decision has been considered. So in the very short term, despite David Gauke's decision today, there's no prospect of John Worboys being released imminently, not least of all because David Gauke has made it clear in the Commons this morning that he will be consulting with John Worboys' victims about the conditions under which John Worboys would be released into the community, his licence conditions, that he wants to have meetings with victims about that to make sure that if he is released, if the judicial review fails, then at least the licence conditions match some of John Worboys' victims' expectations about where he may be allowed to live and where he may not be allowed to go and what he may not be allowed to do while on licence.
Now, the focus has been on the parole board's decision. We don't know, of course, the reasons behind the decision that they took. And the head of that board said that he regarded the independence of the parole board as being extremely important. So what do you make of David Gauke's announcement in the Commons to review the transparency of the parole board?
Well, I think that sounds to be as if it's going to be broadly welcomed on all sides, not least of all by Nick Hardwick, who leads the parole board. He himself has said that he would like there to be more transparency. He'd like to be able to give some reasons in some cases for their decisions. What David Gauke has padded out today is his intention not just to review whether or not the parole board should give reasons for its decisions, but whether there should be some more transparency around the whole process, and of course that key bit about making sure that victims are informed about decisions, which wasn't the case in this case for some of John Worboys' victims. I should say that one of the controversial things about John Worboys is that he's managed to change his name to John Radford. He's been living in closed conditions in Wakefield Prison, where he is still now, and he's not been even in open conditions prior to this decision to release him out into the community.
Daniel Sanford, thank you. Well, I'm joined here in the studio by the chairman of the Justice Select Committee, Conservative MP Bob Neill. Welcome to the Daily Politics. So David Gauke's not seeking a judicial review into the decision to release John Worboys. Should he have floated the idea in the first place?
Well, yes, I think he had to. And in fairness, I was in the Commons chamber for the statement, which I think he handled with actually very great care and precision. And the reason's this. I think because of the public concern about the matter, it was legitimate for him as Justice Secretary to say, I will explore every possible avenue to see if there is a legitimate grounds for review. That's perfectly normal in many cases.
It's quite unusual for the Justice Secretary, isn't it, to take their own parole board or look at the idea of reviewing the parole board's decision, and now having to say that he's not going to go ahead because he's obviously been told there wouldn't be a high chance of success. He's raised a lot of people's expectations.
Well, actually, I think he's shown that he's applied the correct test, as any proper lawyer should. That's to say, to consider if there is an option, then get proper legal advice and act upon it. So I don't think he can be faulted in that regard.
Has John Worboys, in your mind, served long enough in prison for his crimes?
My personal view will be probably not, but I do not have the material which the parole board had, and neither do I have the reasoning for their decision. And actually what I think is important is that David Gauke is widening that review specifically to include the opportunity to change the rules so that decisions are given. And as your piece rightly said, Nick Hardwick himself is on record as saying that he would welcome that. So I think that's an area that we should be pushing for very quickly.
Although, would it not expose the parole board and its members to pressure from the public or a social media campaign or politicians in making a different decision?
Well, there's always that trade-off, isn't there, between the public interest and that turning in to an improper degree of pressure. That's why Nick Worboys is right to say he himself wants more transparency. He will welcome the opportunity to explain decisions more whilst maintaining independence. Other jurisdictions do manage to get that balance, Joe, so we can learn from elsewhere.
Do you welcome the decision not to push for a judicial review of a man who has been a serial sex attacker and is going to be released, basically, after serving less than 10 years, Kate?
I fear that it would heighten the expectations, particularly of the victims, if they don't think that they have reason or cause or evidence to do this. Then they really shouldn't. We're so used to trial by media these days and trial by Twitter, we forget that there is a justice system and we don't have all the information available. My biggest concern in this case is that it's been spread to people that, you know, he has allegedly raped hundreds of women. That might be true, but there were only 12 accusations put against him in court, and we have not managed expectations as to what the result was going to be. We need to believe women more when they come forward. We need to do more to get the evidence to lock people up for longer. But in this particular case, we can't play the justice system as individuals.
How much blame needs to be put at the doors of the prosecution service at the time? Because it was their decision, or the decision was made, not to prosecute or take more cases to trial than the 14 that ended up in court.
Well, I mean, that is absolutely legitimate question. That should be asked. What I get a little uncomfortable with is politicians getting a bit too close to these kind of criminal processes. And in terms of the review, it's certainly the case that should have been looked at. You've got to question whether it should have been flagged up as clearly beforehand. It would have been perhaps more sensible to make a statement having seen the legal advice and said, I've looked at these options and taken it. But there are different ways to handle something as sensitive as this.
I mean, is John Worboys, do you think, safe in your mind to be released?
Well, I don't think we're able, any of us, to say that because we do not have the material before us which the parole board had. I think most of us would say it was a surprising decision given the fact that it had been in closed conditions up until now. But I think the very important point is this, that the parole board could only deal with him for those matters for which he had been convicted, as could the original judge. And that's an issue which does have to be considered. Equally, when those prosecution decisions are taken, that does have to be done independently of political pressure, and it has to meet both what's called an evidential test, is there enough evidence to prove the offence, and secondly, a public interest test. Now, we don't know what was decided and why at those circumstances, but it's always possible, of course, that if further victims were to come forward and the evidence was credible and compelling and met the evidential test, then there is no time limit on the bringing of prosecutions for offences of this kind. But I think you're right, we have to be very calm about it. I think David Gauke was right to say, look, we will look at all avenues, but equally, having had the legal advice, then I think, no doubt, perhaps informed by that and by the factual material he had then to expand his inquiry. The position of the evidence relating to other individuals depends on each individual case.
Bob Neal, thank you. Now, after President Macron's visit to the UK, the British government has made a renewed pledge to allow more child refugees to come